Get ready for the dictation in 3, 2, 1. Start. Any view to the contrary would lead to disastrous result in that even if inclusion of names or non-inclusion of the names of persons in the electoral roll is patently illegal, there would be no remedy at all. Stop. Rule of law being one of the basic structures of our constitution, any interpretation which leads to such a result that is no remedy for the redressal of a legal injury must be held to be not envisaged by the provisions of the Constitution. Stop. An indication in this regard is available in the judgment of the Supreme Court in Mohinder Singh of the judgment in which the conclusion is incorporated reads, we conclude stating that the bar of Article 429B is as wide as the door of Section 100. Read with section. The writ petition is dismissible, but every relief bracket given factual proof bracket close now prayed for in the pending election petition is within reach. Stop. On this view of the law, UBI just IBI remedium is vindicated, election in justice is avoided, and the constituency is allowed to speak effectively. Stop. In the light of and conditioned by the law we have laid down, we dismiss the appeal. Stop. Where the dispute which spirals to this court is calculated to get a clarification of the legal calculus in an area of national movement, the parties are the occasion but the people are the beneficiaries, and so costs must not be visited on a particular person. Stop. Each party will bear his own costs. Stop. Para. As can be seen from the above paragraph, in that case the court held that the writ petition was not maintainable for the reason the ground on which the said writ petition was presented could be raised in an election petition, and therefore Supreme Court observed that the principle of UBI jus IBI remedium stood vindicated in that case, though the remedy stood postponed to a date after the election, which postponement was on sound public policy and the necessity of utmost expedition in the matter of holding election to the parliament and state legislature, which is the very essence of a democratic system. Stop. Applying the same principle, it should be held that in a case of this type, in which the challenge is to the inclusion of ineligible persons in the electoral roll, as the same cannot be adjudicated after election in an election petition, the remedy under Article 226, the only remedy available under the Constitution, is available to an aggrieved citizen. Stop. Para. The coordinate bench of this court at principal seat at Jodhpur in the case of Sampath Singh versus the State Election Commission decided on 30/9/2010 has also considered and rejected the objection of not entertaining the writ petition where the challenge was with regard to deletion of names from electoral rolls and as such the bar contained in Article 243(o) of the Constitution of India was not made applicable. Stop. The coordinate bench also relied upon the judgment passed by the Andhra Pradesh High Court in the case of S. Farakuddin versus the government of AP, reported in AIR 1996, Andhra Pradesh 37. Stop. The relevant extract of the judgment is quote as under. Thus, in view of the law laid down by the Honorable Supreme Court as aforesaid in considered opinion of this court, the contention of the learned AAG that the writ petitions preferred by the petitioners challenging the deletion of their names from the electoral rolls by the electoral registration officer is not maintainable in view of the bar contained under Article 243(o) of the Constitution of India is devoid of any merit. Stop. Thank you.